Good day, and thank you to Heuni for the invitation to be speaking to all of you at this important event. My name is Julia Korkman, and I actually recently learned the term pracademic, which implies apparently a person who is both doing practitioner work and academic work, and I identify strongly with this title. So I've been doing actual investigations of especially crimes against children, investigative interviewing, for example, but I've also been doing research throughout my career, and at the moment I'm one of the two leaders of a research group in legal psychology at Åbo Academy University here in Finland. And I'm also the new president-elect of an association called the European Association of Psychology and Law. This association has a wide network of researchers who publish about issues relevant to legal procedures based on human or on psychological science. So these issues are highly relevant, I expect, to many of you who are following this webinar. So please familiarize yourself with this association. And I can't resist saying that the next year's yearly conference will actually take place in Romania. And as we have attendance from Romania, I thought I would bring that up. You'll find the information online, of course. Within my research group and within my own research, we've been looking at many issues quite relevant for today's topic. I've researched particularly crimes against children and sexual crimes, and also more recently asylum procedures, and both interviews and decisions in asylum procedures. I've also trained for more than a decade legal professionals and police officers, particularly in investigative interviewing and assessments of witness statements and the issue of memory in the legal context. So I'm quite happy to speak to you about these issues, and I'm going to say just a few words about memory in general. What do we remember? What we remember is dependent on what is relevant for us within a given context. And if we think about human beings, what is relevant is very dependent on our own background. It's dependent on culture. There are cultural differences in what kind of things people tend to attend to. It's very much based on our previous experiences. For example, previous trauma experiences can influence the way we experience new situations. And of course, the context in which we do remember. If you look at it from an evolutionary perspective, human beings are typically focusing on issues, or let's say sex and violence are important for our survival, and these issues are such that they get our interest and we tend to remember, which you can see maybe in popular culture. These are highly frequent topics. We also know about memory that memories are highly malleable, so they are prone to changes, they are prone to distortions, to reinterpretations. It can go in both ways. You can understand the situation you've been in better later on with more understanding. This we can see in crimes against children, for example. But you can also even create completely false memories of situations or something in between. You can also say that memory tends to be favorable to us, so people who are psychologically fairly well-being tend to remember things they have done or that has happened to them from maybe a fairly positive light. These are sort of general issues about memory, but there are many misconceptions about memory, and maybe one of the most important ones, which is really quite frequent in the legal system, is that memory would work like a recorder, a video recorder. And this is certainly not true. Every time we talk about an event, every time we process it, it changes to some extent. So the more times you go through an event, the more the likelihood that it changes will increase. And this is important if we think of how our legal system functions. There's also a problem which is frequent in the legal procedures related to things that have happened several times. It may seem that if you experience a thing many times, you would remember it better, but it's not really as simple as that. Paradoxically, unique experiences that are completely, like one unique experience can actually be better remembered than several similar, because these sort of create a kind of, we psychologists call it script memory, so this is how it usually happens, and the individual details may sort of get lost. And this is very relevant to, for example, cases of intimate partner violence. Victims can be struggling to identify certain aspects of each and every event, but they may be much more generalized in how they describe these issues. And this goes for both traumatic and non-traumatic events. This is a very basic feature of our memory. Then related to trauma in particular, there are some very strong notions that are also a bit problematic. And one is that traumatic memories would be blocked and cannot be accessed. And this particularly seems to be common when talking about child sexual abuse. This is not really true. In fact, according to all the available research, traumatic situations are less likely to be forgotten than neutral, positive ones. Of course, they can be forgotten, like any memory. They can be distorted or re-evaluated based on new understanding, and this maybe is one of the reasons why this notion is strong. But I would expect much more common is that people do not wish to talk about or think about traumatic events and may struggle to describe them. So it's maybe more of a psychological hinder than a real memory block. And also if you think of child sexual abuse, which is one of the topics where you often hear this claim, we know from research that many children tell about such experiences only a long time after they have occurred, and part of this can be due to the fact that they have not understood the situations when they occurred. So there are sort of other explanations. Then, on the other hand, last summer, for example, I had a discussion with a friend of mine who said that, well, if something utterly traumatic happens, you would remember it forever. And this is sort of a yes and no question. You would probably remember that an utterly traumatic situation has occurred. You may remember some of the feelings, or that you saw blood or something, but just as in other memories, these details can really change. They can be forgotten or distorted, and we know that during very high stress, this affects memory negatively. So people might not be as good at recording or remembering things at that moment. Not being able to forget is actually a very typical feature of post-traumatic stress disorder. So it's more that these people struggle with not being able to forget. They get intrusive thoughts and nightmares, rather than that they would forget these traumatic events. And I think these are really important. If we look at other features of traumatic memories, it's true that traumatic memories can be skeletal, and I would say that it's normal memory functioning, in the sense that all memories tend to focus on central details that are central for the person. But in traumatic situations, these memories can be even more skeletal. So you focus even more on central details rather than peripheral. So a lot of less important details can be forgotten, and only a few really central ones. And what is central for the individual, for example, the victim, might not be what is central in a legal process. So this is, of course, to be noted. As I said, exposure to high stress has a negative impact on memory. So, for example, recognizing a person that has been threatening you very violently can be very difficult compared to recognizing a person you've had more neutral encounters with. But more importantly, it may be significantly stressful for victims to recall and tell about traumatic experiences, and our system needs to adapt to this. There are ways to maximize the possibilities for victims and witnesses to give detailed accounts in a reliable manner, and this is what we should develop in our legal justice system. We really are not there yet. First and foremost, we know from an abundance of research that how you ask is what you get. The way in which investigative interviews are conducted, the way in which witnesses are heard in legal processes. And I say witnesses because this is true for victims, for witnesses, for defendants. This is really crucial. When you try to assess the credibility of an account, you have to look at how the account was elicited. And we know that enabling full accounts, as full accounts as possible, getting as much information as the person can remember, requires time, a calm atmosphere, and a sense of trust, or something that is often referred to as rapport. So you have to create a situation where the interviewer, interrogator, whatever the name used in various countries are, often the investigative police officer, where they create an atmosphere in which the witness victim feel they are heard, they are listened to, and they are taken seriously, and that there is room for searching memory. It's okay to cry if needed, it's okay to have a break, and as we know, this is not very typically the case I think throughout Europe and globally. Memory is associative. So when you try to remember any kind of event, but in particular this is important for remembering stressful or traumatic experiences, the more a person can recall, even about things that are not crucial to the investigation at hand, the more they will remember all in all, and the more the likelihood increases that they will remember also really important issues. In police investigative interviews, based on research, we know that very often they go to direct questions quite early on and ask specifically about justice relevant issues, or issues relevant to the justice process. But this is not, from a memory perspective, very good. You should actually let interviewees say everything they simply can remember. And there are interview methods that have been based on this. And I know, for example, in the UK and in some other countries, police are quite efficiently trained in applying these kinds of interview methods, where you actually give the time, you let the interviewee speak at their own pace, you are putting a lot of effort into creating report. And this is something I think every witness should have also. I mean, every person investigated or interviewed in the pre-trial investigations. We also know that memory, when you describe an event, it doesn't necessarily present itself in a chronological order. Memory doesn't really work chronologically. And this is important in the investigative interview. This interviewer needs to adapt to how the interviewee remembers rather than the other way around, which again is unfortunately probably the case in very, very many situations. And as I said, a stressful environment, a stressful situation has negative effects on memory, both in the situation where you are remembering an event and, of course, also in the initial event. If we think of the court proceedings throughout Europe, globally, it's clear that they tend to be stressful. Many countries do not really apply a lot of methods to decrease the stress for the victims. And here much could still be done. In Finland, for example, where, of course, I am most familiar with the court system, it is quite formal. People can come into the courtroom without really understanding who is who and who they are supposed to look at, etc. This is increasingly put under attention, but I think much could still be done. They also expect, and are right in expecting, that they will be posed a lot of skeptical, leading questions, critical questions, and this certainly does not help feeling at ease and calm and explaining or describing their experiences. In most countries, very little adjustments are being made to take this into account. And we have, I think our legal system is full of people who are traumatized, certainly in the victim position, but also often in perpetrator positions. And then we have, of course, asylum cases, for example, where we also are dealing with highly traumatized people very often. So we really should ensure that the environment in which these people are heard is as de-stressing as possible. Time is one of the major enemies if you look at memory, and in terms of quantity, in terms of quality. The quantity decreases very rapidly over time, and the quality also decreases because a lot of other things, if you're subject to a crime or you're the victim of a crime, you will be likely to talk about this matter with other people, you might read about it in the newspaper, etc. And this can create confusion, distortions, and then if you later on tell about these experiences in court and there are distortions or changements, this will be again taken easily as a sign that the account is not credible or reliable. So memory should really be collected and preserved as soon as possible. And this means during the pre-trial investigation. From a memory perspective, this is really very clear. Recording should be enforced always in the pre-trial investigation of crimes against violent crimes, sexual crimes, crimes of a very important matter. There is research suggesting that 2/3 of the details in rape victims' accounts are lost between the pre-trial investigation and the court hearing. This is an enormous amount, and the victim pays very dearly for this. So in this study from New Zealand, they compared victims' interviews within the pre-trial investigation with the same victims' court hearings, and really a lot of detail were lost. This means that by the time we are in court, and normally in many countries this is the hearing that counts. What counts is not what has been said in the pretrial investigation, but what counts is really what is coming up here. There's much less to go on, there's much less evidence. Another aspect, of course, is that for a traumatized victim to have to wait for the trial, knowing that they will be scrutinized, knowing that they should try to remember every detail as much as possible, is clearly not beneficial for their recovery. I work closely with the Rape Victims Center here in Helsinki, at the Helsinki University Hospital, and just a few days ago I had a presentation together with the psychologist and psychotherapist working there with the rape victims, and he was describing how many of the victims struggle waiting for the trial. In Finland they can wait for maybe 2 years before the first trial, and they are quite aware that they need to hold on to every detail. They can't forget them or they will be criticized for that. This is, from a psychological point of view, of course terrible, and it would be easy to easy but at least practically possible to address through recording the pretrial investigative interviews, which could then be used in court, maybe not as evidence in chief, but as a basis for which to continue, so the victims would not have to repeat everything that was said in the pretrial investigation. They could see that interview, and then later on questions could be asked in court as our legal system requires. So what to do? First and foremost, train all who interview or interrogate hear people in legal processes. They need the fundamentals of human memory in general, and in particular related to stress or traumatic situations. There's a lot of very good training going on. There's a lot of legal psychology-based training that is taken into account, both the legal needs, the needs for assessing credibility and for ensuring credibility and a due process, but also considering the impact of trauma, of human memory, etc. The second thing, as I mentioned, video record pretrial investigative interviews. This is done in some countries. For example, the UK has really been a forerunner in this area. And in Norway, this has also recently been enforced, is my understanding. In many other countries, no. In Finland, Sweden, we do not generally video record, even in very important cases. Maybe this is slowly changing, but this is really something that should happen on an international level. Today, it's not technically that difficult. In all cases, and also in the case of children, of course, in many countries, children are heard in the pretrial investigation on video, and this record is used as evidence in chief. And this is clearly a good system if we consider children. You have a child at the age of 12, if they have to wait 2 years before the trial, it's a very, very long time in child's life. So they really need to be able to move on from that experience, and sort of, now they've done their part when they have been interviewed. In every case, regardless of how you make use of that video record, it can certainly help to assess what was remembered immediately. Also, our system tends to look too much at, for example, trauma reactions, or how a victim describes what kind of emotional feeling they have when they describe a situation. Based on research, this is not really something you should put that much effort on, but it's clear that if a person has been, for example, raped, the reactions 2 weeks after after the rape will be different from 2 years later on, and the victim this should be expected. It shouldn't lead to confusion about the witness credibility. And also adapt court hearings. The court hearings are, as I said, not really made in a manner that is making it easier for persons to come forward with everything they know. Remote hearing is a big issue today, and we're actually together with Heuni embarking on a research project on remote hearings. There are a lot of prerequisites, of course. There's a lot of things need to be considered if we hear people remotely from another place than the physical courtroom, including who is there, making sure it's a safe environment, nobody else is influencing in a negative way what is being said. But there are very positive experiences. For example, in Australia with vast distances, and one of the experiences has been that it does seem to improve the situation for vulnerable witnesses in particular. And remote hearing, it can happen from the next room. It doesn't have to be from far away. It can just be a way to ensure that there's an intimate atmosphere, the interviewer and can sort of make a contact with the interviewee. I also want to point out that there is a new set of principles that have been published this year by UN Special Rapporteur Juan Mendes, and there's a very big group of scientists behind this standard, behind these principles. It's called the New Standard for Effective Interviewing by Police and Others while Respecting Human Rights. Within these are mostly focused on interrogations of suspects, but actually quite a lot of what is in here is applicable to any situation where you want to hear a person. It's about report, it's about open-ended questioning, and it's about keeping record on how the interview happens. So they actually clearly recommend video recording of investigative interviews, which is clearly something that research would be backing. We know that in many countries, including Finland, and I know many other European countries at least, at the moment, as I said, police are not recording their investigative interviews. They are writing summaries or some kinds of written statements based on these interrogations or interviews. Based on research, these really leave out a lot. They do not necessarily correspond very well to what has actually been said, and at least they do not show what has been asked and what may not have been asked. And again, this may create confusion as to whether, for example, a discrepancy in a witness statement comes from that witness themselves or from the police. And again, I think this is really important when we look at vulnerable victims, witnesses. So I leave you with this notion and invite you to have a look at the website of our research group in Åbo Academy, and if there are any inquiries, you feel free to contact me via email as well. And again, I want to thank Heuni for this opportunity to talk here today, and it's inspired of this maybe a little bit critical point of view, stating that there is so much that should be done and could be done. It is, I am happy to see that there is much more movement in this regard, and there certainly is a lot of new research going on around the issue of traumatized witnesses and victims and how they should be heard and assessed. So I think the legal system has a lot to make use of when it comes to scientific research, and so we can work on this together. Thank you so much.